Hello, this is Professor Moore, and this is another heart-stopping video on civil procedure. This time I'm doing a bar review class for civil procedure, since civil procedure is on the multi-state bar exam for the first time this February. And this little segment will be on supplemental jurisdiction. So, fair warning to anyone watching this who is expecting a subtle and nuanced presentation of the subject. First of all, the term now is supplemental jurisdiction. So if you see the words pendant jurisdiction or ancillary jurisdiction as one of the choices on a multi-state bar examination question, that answer is wrong unless it says something like pendant jurisdiction is an outdated term. So I'm not even going to tell you what the difference is between pendant and ancillary jurisdiction is, because it's not relevant. So what is supplemental jurisdiction? Well, first you have to have more than one claim asserted in the same lawsuit. And of course, there can be many, many claims asserted in one federal lawsuit by many different people. We're going to boil it down to two claims, and we're going to call one the it claim and the other the wannabe claim. So the it claim is the claim that a federal district court would have original subject matter jurisdiction over on its own. So there's diversity over this claim. There is federal question jurisdiction. You know, the government's a party. For some reason, the it claim, there's federal subject matter jurisdiction. The other claim is the wannabe claim. Here, the federal district court would not have original subject matter jurisdiction over this claim if this claim were brought on its own, just as a single claim. So, simple example based on United Mine Workers versus Gibbs. We have a plaintiff versus a defendant. Both of them are citizens of state A, so we do not have diversity. The plaintiff has two counts, two claims against the defendant. They both arise out of the same events. Count one is violation of the National Labor Relations Act, which is, of course, a federal statute. So this is the it claim. There is original subject matter jurisdiction over count one under federal question jurisdiction. Count two is a state law claim for tortious interference with contract. This is the wannabe claim. As a state law claim, and with these parties being citizens of the same state, this could not be brought in federal district court on its own. Here's another example. We have a plaintiff versus two defendants. The plaintiff is from state A, the two defendants are both from state B. We have complete diversity. Let's assume the amount in controversy is met. But now, defendant number one files a state law cross-claim against defendant number two. So clearly, because defendant 1 and 2 are from the same state, there is no diversity for that cross-claim. So if defendant 1 were just to have sued defendant 2 on a state law claim on her own, this would not have gotten into federal court. So plaintiff's claim is the it claim. There's original federal subject matter jurisdiction over the plaintiff's claim. Defendant 1's claim against defendant 2 is the wannabe claim, could not be brought in federal court on its own. Final example, and there are many, many examples, but I'm just giving you kind of simple ones, of a situation where supplemental jurisdiction might arise. We have a plaintiff versus a defendant for $100,000. They're from different states, state A and B. We have complete diversity. We have the amount in controversy. Now the defendant files a counterclaim against the plaintiff, but this time the defendant's claim is only for $25,000. there's diversity between the parties, but the defendant's claim fails to reach the amount in controversy that would be required if the defendant were simply to file this claim on its own in federal court. So the plaintiff's claim in this hypothetical would be the it claim, gets into federal court on its own. The defendant's counterclaim is the wannabe claim, could not be brought in federal district court on its own. So those are situations where we need supplemental jurisdiction to get that wannabe claim under the jurisdiction of the federal district court. Okay, so before we get into the ins and outs of of supplemental jurisdiction, first make sure that that second claim that we've been calling the wannabe claim, make sure that there isn't actually original jurisdiction over that second claim, making it in effect a second it claim. So to take a variation on example number 1, which was the United Mine Worker versus Gibbs takeoff. So we have the same thing. We have a plaintiff with 2 counts against a defendant, but this time, instead of these 2 parties being from the same state where we didn't have diversity, let's hypothetically make them from 2 different states so that there is diversity over that state law claim. So the plaintiff still has the same 2 counts. There's jurisdiction over count 1 based on federal question, of course also based on diversity, and there's jurisdiction now over count number 2 on its own as a diversity claim. Even though it's a state law claim, we have diversity and we have the amount in controversy. So we don't need to think about whether there's supplemental jurisdiction over count 2 anymore, because there is original subject matter jurisdiction over count 2 under the diversity statute. So we don't need to go forward with the supplemental jurisdiction analysis. And this may make a difference on the way that your choices on a multiple choice question read. An example of this would be question 9 in the handout that I gave my students. Now, I'm going to let you pause this and read question 9 for yourself, and I'm going to go right on to the next slide. So you probably already know that the best way to approach these types of civil procedure problems is to diagram them. So essentially what we have here is an original claim by a plaintiff against a defendant. There's diversity, the amount in controversy is met, and then the defendant goes and files a third-party complaint against a third-party defendant. Now, the defendant and the third-party defendant are both citizens of the same state, and so you might be thinking, oh, maybe this is what the question is going to be about. But no, the question is actually about, now that defendant has in fact third-partied in the third-party defendant, the plaintiff says, oh, well, I want to sue the third-party defendant too. So the plaintiff amends the complaint to bring a claim against the third-party defendant. It so happens that the plaintiff and the third-party defendant are citizens of different states, and that the plaintiff's claim against the third-party defendant also exceeds the amount in controversy requirement. Therefore, there is original jurisdiction over the plaintiff's claim against the third-party defendant. We do not need supplemental jurisdiction. So, looking at the choices, the correct answer is C. Yes, because the requirements of diversity jurisdiction have been met. The only other choice that might have fooled you is yes, because the court has supplemental jurisdiction. Answer D. Answer D would be wrong because, in fact, we don't need supplemental jurisdiction to encompass the plaintiff's claim against the third-party defendant. All right, so let's get down to supplemental jurisdiction itself, assuming that we do need it, that we do not have original subject matter jurisdiction over the wannabe claim. So there's either 2 or 3 steps to deciding if we have supplemental jurisdiction over the wannabe claim. The first step, the first 2 steps we always have to do. And the third step we have to do if the original case is in federal court only based on diversity. So the first step is that we have to do in every case, we identify the IT claim, the original subject matter jurisdiction claim, and we identify the wannabe claim that's being asked about, and we ask, do these two claims, the IT claim and the wannabe claim, have a common nucleus of operative fact? In other words, do these two claims arise from the same transaction or occurrence? Do they arise out of the same thing that happened? This should be either stated in a multiple choice question, or it should be so obvious as to admit of no discussion. So if the answer is yes, then you have supplemental jurisdiction over the wannabe claim. It's as simple as that. So in other words, if we have one claim over which the federal district court has subject matter jurisdiction, and we have another claim that the court wouldn't have jurisdiction over, but it's based on the same series of events that the first claim is based on, why wouldn't we be able to take jurisdiction over it? And that's what the first section of the supplemental jurisdiction statute does. So in other words, if the IT claim and the wannabe claim do not arise from the same transaction or occurrence, then there cannot be supplemental jurisdiction over the wannabe claim. So you're done. No supplemental jurisdiction. If these two things do arise from the same transaction or occurrence, then yes, you have supplemental jurisdiction, even if only for a moment, over the wannabe claim. So you go on and you ask, this first claim, the IT claim, over which there was original subject matter jurisdiction, was that jurisdiction based only on diversity? Okay, if that question is answered no, which usually means no, it was based on federal question, not diversity, then you can stop. The wannabe claim remains under the supplemental jurisdiction granted by the first subsection of the supplemental jurisdiction statute. However, if the IT claim, the one that has original subject matter jurisdiction, is based solely on diversity, then unfortunately you have to go on to the third step. The third step is, okay, we've got this claim that's under the original federal jurisdiction only by basis of diversity. And we have to ask then, does the dreaded second subsection of the supplemental jurisdiction statute take supplemental jurisdiction away from the wannabe claim that we just said had supplemental jurisdiction because it arose out of the same transaction or occurrence as the IT claim? All right, so I've put 1367B in its lovely entirety on the screen here. And people's heads tend to explode when they look at 1367B. So I'm going to break this down and just go into what exactly this means and what you should look for. Now, there is kind of a policy that drives the madness of 1367B. The sort of policy that's behind it is an idea that a plaintiff should not be able to avoid the complete diversity rule by the introduction of different parties and claims. So you remember the complete diversity rule. There can be no plaintiff and defendant from the same state. And so the theory is, here's what the plaintiff wants. The plaintiff has two defendants that she wants to sue. She's a citizen of State A. The two defendants are citizens of State A and State B. Obviously, this violates the complete diversity rule. She can't sue defendant number 2. So what she does instead is she sues the one defendant who is diverse, namely defendant 1, hoping that because, say, these are joint tortfeasors and defendant 1 is going to file a third-party claim against defendant 2 for contribution, the plaintiff is hoping that defendant 1 will in fact bring defendant 2 into the lawsuit via Rule 14 and via a third-party claim for contribution. And then if there were no prohibition on the plaintiff doing this, the plaintiff would then happily bring a claim against defendant number 2, now that defendant 2 is into the lawsuit, and the fact that they are from the same state would be magically taken away. So Congress, in drafting 1367B, did not want that to happen. That's why you get this bizarre language that takes supplemental jurisdiction away from claims by plaintiffs against people made parties under blah, 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 and blah. So we're going to go through that. Okay, so how would we in fact analyze this under the current supplemental jurisdiction statute? We start out with a plaintiff versus a defendant. We're going to assume that this is based on diversity and that the amount in controversy is met. The defendant goes ahead and files a third-party complaint against the third-party defendant, and now the plaintiff wants to file a direct claim against the third-party defendant. What's the it claim? Plaintiff versus defendant. What's the wannabe claim? Plaintiff versus third-party defendant. First question, do these two claims arise out of the same transaction or occurrence? Let's assume that they do. Let's move on to the second question. Is the it claim, plaintiff versus defendant, in federal court solely because of diversity? Yes, it is. We're assuming there's no federal question involved here. Therefore, we have to go on to the third question. Is plaintiff's claim against the third-party defendant, the wannabe claim, is that a claim by a plaintiff against a person made party under Rule 14? Well, yes, it is. Rule 14 is the third-party defendant claim. So since we don't have diversity between the plaintiff and the third-party defendant, in other words, they're both citizens of State A, that claim could not have been brought in federal court on its own, and therefore there is not going to be any supplemental jurisdiction over the plaintiff's attempted claim against the third-party defendant. However, if you change the citizenship of the third-party defendant to State B, this changes the result. First of all, we want to look at now, is there supplemental jurisdiction over the defendant's third-party claim against the third-party defendant, because now we've got those two parties from the same state, State B. And so brought on its own, the defendant's third-party complaint against the third-party defendant would not have federal jurisdiction. So we ask our first question. Does the it claim, plaintiff versus defendant, and the wannabe claim, defendant versus third-party defendant, do these two claims arise from the same transaction or occurrence? Let's assume that they do. You probably couldn't have a third-party claim that didn't. So we assume the answer to number 1 is yes, they arise from the same transaction or occurrence. So we go on to step 2. Is the original claim, the it claim, in federal court solely on the basis of diversity? Well, yes, it is. So then we have to go on to step number 3. Is the wannabe claim a claim by a plaintiff against a person made party under Rule 14? Well, yeah, TPD is a person made a party under Rule 14, obviously, but this time we don't have a claim by a plaintiff. We have a claim by a defendant. So when it says claims by plaintiffs, it literally means a plaintiff. It doesn't mean a defendant. So there is, in fact, supplemental jurisdiction over the defendant's claim against the third-party defendant, despite the fact that they are both citizens of State B. Now this time, plaintiff wants to bring a direct claim against third-party defendant. There may, in fact, be original jurisdiction over the plaintiff's claim against the third-party defendant because plaintiff and third-party defendant are from different states. Depending on the amount in controversy, if it's more than $75,000, then there will be original jurisdiction over the plaintiff's claim. However, there's still if it was less than 75,000, there still would not be supplemental jurisdiction because this is still a claim by a plaintiff against a person made party under Rule 14, and if it's less than the amount in controversy, it could not be in federal court on its own. All right, so making our way through these rules, remember, we are not going to have supplemental jurisdiction over a claim by a plaintiff against a person made party under Rules 14, 19, 20, or 24. What's Rule 19? That is the rule that requires the joinder of so-called indispensable parties. We are going to call this particular hypothetical party Mr. Absent. So here's what the plaintiff did when the plaintiff filed its complaint. They filed this good old plaintiff versus defendant. There's diversity. They're citizens of state A and state B. The amount in controversy is met. However, the plaintiff knew, this is the theory behind this policy, the plaintiff knew that Mr. Absent was really an indispensable party who should have been joined, or a required party who should have been joined as a defendant. And the reason that the plaintiff didn't join Mr. Absent as a defendant is that Mr. Absent is a citizen of the same state as the plaintiff, and the joinder of Mr. Absent as a defendant would have destroyed complete diversity. So hypothetically, if Mr. Absent was joined as a defendant and the plaintiff tried to assert a claim against Mr. Absent, it would be a claim by a plaintiff against a person made a party under Rule 19, and there would not be supplemental jurisdiction over this claim. Trust me, it really pays not to think about that too hard and just blindly accept the language of the statute. Another way that a person added under Rule 19 could be added is that they could be added as a plaintiff. On the last screen, we had them added as a defendant. So here, the absent party, Mr. Absent, would be joined, or supposedly could be joined as a plaintiff, and now we make him the same citizenship as the defendant, thus again destroying complete diversity. And so we say, well, if Mr. Absent, once he gets thrown into this litigation as an indispensable party, as a plaintiff, tries to assert a claim against the defendant, now it is a claim by a person proposed to be joined as a plaintiff under Rule 19. That would be Mr. Absent, and there would be no supplemental jurisdiction over that claim. Moving right along to Rule 20, that is the rule that governs permissive joinder. So when a plaintiff originally sets up a lawsuit, if the plaintiff wants to add co-plaintiffs, or if the plaintiff wants to sue more than one defendant, or both, Rule 20 is the rule that governs when that can be done. So let's take an example where the plaintiff wants to sue two co-defendants, imaginatively named Defendant 1 and Defendant 2. So we set it up where the plaintiff is a citizen of State A, the two co-defendants are citizens of State B. We have complete diversity. However, the plaintiff's claim against Defendant 1 is for $100,000. So by itself, that could get into federal court. The plaintiff's claim against Defendant 2 is only $25,000. So we ask our first question, does the IT claim, which is plaintiff's claim against Defendant 1, and the wannabe claim, plaintiff's claim against Defendant 2, do they arise from the same transaction or occurrence? Let's assume that they do. Now we move on. Is jurisdiction over the IT claim premised solely on the basis of diversity? Yes, it is. So we have to go on to step 3. Is the wannabe claim a claim by a plaintiff against a person made party under Rule 20? Well, yes, it is. Therefore, because we don't meet the amount in controversy in the wannabe claim, so it couldn't be brought into federal district court on its own, there is no supplemental jurisdiction over the wannabe claim. You may recall a different setup of the Rule 20 situation with the permissive joinder of plaintiffs rather than in the last slide we had the permissive joinder of defendants. So this is like the Star-Kissed Tuna case, which was consolidated with the ExxonMobil case in the Supreme Court. Some of you may recall reading that in civil procedure. So this time we have two plaintiffs and one defendant. The two plaintiffs are citizens of the same state. The defendant is a citizen of a different state. So we have complete diversity. This time plaintiff 1 has a claim against the defendant. Sorry, those arrows are not pointing the right place. I apologize. But disregarding the placement of the arrows on my diagram there, Plaintiff 1's claim against the defendant is for $100,000. Plaintiff 2's claim against the defendant is for $25,000. So Plaintiff 1's claim is the it claim that could get into federal district court on its own. Plaintiff 2's claim is the wannabe claim that could not get into federal district court on its own. So first we ask the question, do the it claim and the wannabe claim arise from the same transaction or occurrence? Yes, they do. Let's assume. Is jurisdiction over the it claim based solely on diversity? Yes, it is. So we have to go on to step 3. Is the wannabe claim a claim by a plaintiff against a person made a party under Rule 20? Well, Plaintiff 2's claim is certainly a claim by a plaintiff, but is it against a person made party under Rule 20? No, it isn't. It's just against a plain old defendant. This defendant was not made a party under Rule 20. So the Supreme Court held that, in fact, in this situation, there is supplemental jurisdiction over Plaintiff 2's claim, even though it's less than the amount in controversy. Moving on to the final rule that is mentioned in the second section of the Supplemental Jurisdiction Statute. This is claims by plaintiffs against persons made parties under Rule 24, over which there is no supplemental jurisdiction. Now again, we are talking about someone that I'm going to call Mr. Absent, someone who was not included in the original setup of this lawsuit. This time, nobody wants him. The plaintiff didn't add him. The defendant doesn't try to add him. But somehow Mr. Absent finds out about this lawsuit and he wants to be in. So he files a motion to intervene. So what plaintiff originally filed was just our typical plaintiff versus defendant with diversity jurisdiction. And if Mr. Absent is allowed to intervene as a defendant, let's say that he is a citizen of the same state as the plaintiff. On the diagram, that would be State A. Or Mr. Absent might be allowed to intervene as a plaintiff, and let's say that in that case, Mr. Absent would be a citizen of the same state as the defendant. In either case, the joinder of Mr. Absent, the allowing of Mr. Absent to intervene, would destroy complete diversity. So if in the first situation the plaintiff were allowed to make a claim against Mr. Absent as a defendant and they're citizens of the same state, the plaintiff, there would not be supplemental jurisdiction over that claim under the Supplemental Jurisdiction Statute. Or if Mr. Absent was allowed to intervene as a plaintiff, then that would be a claim by a person seeking to intervene as a plaintiff under Rule 24. In either case, the Supplemental Jurisdiction Statute does not allow supplemental jurisdiction over these claims. So it just remains to go through a couple of questions that were given to the class. So I'll give you a minute to read question number 8. So hopefully you will have recognized that question number 8 is exactly the same as an earlier slide that we did. Third-party defendant is joined under Rule 14. We originally had a garden variety plaintiff versus defendant for $80,000. There is original jurisdiction over that claim, so that's the IT claim. It's based solely on diversity. Jurisdictions based solely on diversity over the IT claim. After the defendant files a third-party claim against the third-party defendant for $60,000, what we've got is a claim by the defendant against the third-party defendant. Both of them are from State B, and the claim does not reach the amount in controversy. It's only for $60,000 rather than in excess of $75,000. So without the supplemental jurisdiction statute, there would not be original jurisdiction over the defendant's third-party claim here. So this is the wannabe claim. We're assuming that the IT claim and the wannabe claim arise out of the same transaction or occurrence because the question tells us that they do. And so we ask, does the wannabe claim, is it a claim by a plaintiff against a person made party under Rule 14? No, it isn't, because this isn't a claim by a plaintiff, it's a claim by a defendant. So now we look at the choices, and the last choice, choice number D, is the right answer. The court has supplemental jurisdiction over the State B citizen's third-party claim. Now, even if the court, after all of that, has supplemental jurisdiction over the wannabe claim, the court still has discretion to decline to exercise that supplemental jurisdiction. And this is the third section of the supplemental jurisdiction statute. I kind of doubt that the multi-state bar examination is going to get quite this detailed, but just in case it does, the three main reasons that the court would have discretion to decline supplemental jurisdiction would be if this wannabe claim presents a very novel issue of state law that the federal court would feel that the state court has better expertise in deciding. Secondly, does this wannabe claim, this state law claim, in fact substantially predominate over the IT claim, the federal claim? In which case the state law claim is kind of the tail wagging the dog. In that case, the federal court might decline to exercise its supplemental jurisdiction. And thirdly, the federal court might have gone ahead and dismissed all the IT claims, all the federal claims, leaving this poor wannabe claim out on its own. That's the situation that is addressed in practice question number 10. So go ahead and pause and read question number 10. So hopefully you've diagrammed question number 10, and what we have is a novelist versus a blogger. They are both from State A. There is no diversity jurisdiction between them, or there's no diversity between them. The novelist's first claim, claim number 1, is for federal copyright infringement, so it, of course, is not only within the federal question jurisdiction of the district court, it is within the exclusive jurisdiction of the federal district court. Claim number 2 is a state law claim for unfair business practices. It arises out of the same transaction or occurrence, namely the plagiarism, as claim number 1. So claim number 2 was easily within the supplemental jurisdiction of the district court. And the two claims went along into trial when all of a sudden the legs were cut out from claim number 1 and it was dismissed because it turns out the novelist hadn't in fact filed the copyright properly. So now we are left with claim number 2, which the novelist of course could not have brought against the blogger in federal district court on its own. So the supplemental jurisdiction statute actually allows the district court the discretion to go ahead and dismiss claim number 2 at this point, or in its discretion go ahead and keep claim number 2 because it once had supplemental jurisdiction over it. So now we go to the choices, and choice number B is the correct answer. The court may, in its discretion, dismiss this action since the federal it claim is now gone, or it can hear the state law claim because it did have supplemental jurisdiction over it properly. So that's it. Thanks for listening.